Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate at Samfiru Tumarkin. I'm the managing associate of our Calgary office here in beautiful Alberta. I'm here today to answer your questions about employment law. This is the employment law Q&A. Feel free to put your questions in to our chat. We're going to get to as many of them as possible today in the next half hour. I'm battling a cold. I'm sorry about that. So I might sound a bit snuffly, but my mind is sharp. So shoot at me any questions you have. I'll be happy to answer as many as I can. Fall is upon us, and we've started getting a few questions at the office from some people who are seasonal workers. And the questions generally are, whether seasonal workers are entitled to severance. There's this misconception out there that if you're a seasonal worker, you're not entitled to any severance if you're terminated. So that's not precisely the case. What I can tell you is true. Imagine you work at a golf course. You've been working at this golf course for the last 5 years, and the golf course closes in October and reopens in April. If they lay you off in October saying you're going to come back in April when we start up again, then you're not generally entitled to severance in that case. Okay, but if you've been if you've been recalled every year for a few years, and then one year they say, well, listen, we're closing down now, and we're not going to recall you ever again. This is a permanent layoff, if you want to call it that, or a termination. Then that entitles you to severance. Okay, so if it's just a regular kind of layoff and business as usual, then you'll come back in the spring. Then no, you're not entitled to severance for that. You're a seasonal worker in that case. But if it's been a series of seasonal jobs, then you are entitled to severance if they put a final end to it. If they say this is a permanent layoff, you're not going to be coming back. All right, we have some people coming in already. Thank you. Sandy is asking, under Canada Labor Code 239, 8 and 9, can pensions accumulate while on unpaid medical leave? If so, employee contributions out of pocket would be based on what number, since there are no wages. So you're a federally regulated employer. That's a good question. I have to tell you, I don't have, Sandy, Canada Labor Code Section 239 front of mind. That might require a bit more of a legal opinion. You might have to call into us and set up an appointment so we can look into that for you. If you want to speak to one of us, the website is there on the screen. It's employmentlawyer.ca. employmentlawyer.ca. If you visit that, you'll be able to get in touch with us, set up an appointment, and discuss your options going forward. We have another question coming in here from Raj Sharma. It says, hi, is it better to start severance package negotiations with your company on your own first if you are short on budget? I heard lawyers take 30% of the cut and the other 30% goes to taxes. So you're left with 40%. Well, my advice is it's not because we take a percentage of the severance as a fee. My advice to this, in my experience, has been that employees who negotiate on their own don't get the same treatment, don't get the same response as they would if they had a lawyer. All right, that's just my take on it. You mentioned 30% for taxes. 30% for taxes is coming off whether you negotiate or not with your employer on your own, or with with the help of a lawyer. Usually, in terms of lawyer fees, the way it works out is that you'll be taxed on what's left after your lawyer's been paid. Okay, so you don't get taxed on the full amount. You get taxed on what's left after your lawyer's been paid. That's usually how it works out. I've seen a lot of people get shortchanged by their employers when they try to negotiate on their own, and the attitude really shifts once a lawyer comes in. My challenge, frankly, though, is you try. You imagine you're entitled. You look at our severance pay calculator. Severance pay calculator is at pocketemploymentlawyer.ca. You go on there and it tells you you're entitled to 12 months of severance. but your own employer has only offered you 3 months of severance. So you tell your employer, well, listen, I'll take 30% less than 12 months because that'll save both of us the lawyer fees, for instance. All right, so let's give me 9 months and let's wrap this up quickly. And your employer comes back, as they often do, and say either no or say, well, I'll give you an extra 2 weeks. So now you're 3.5 months. And now you're thinking, well, I really just want to get a quick deal. I'll take 6 months. So why don't you just give me 6 months? And then they're like, no. We're like, we'll give you an extra month, an extra 2 weeks. So now you're at 4 months. And then you call me and I tell you you're entitled to 12 months. And you tell me, great, go get me 12 months. And I write to the employer and say, give Raj 12 months. That's what he's owed. The employer says, well, Raj's last offer to us was 6 months. I don't understand where this is coming from, 12, right? And so now I'm stuck with you having kind of shortchanged yourself to get a quick deal that it backfired. And now I have to sound quite unreasonable in saying, well, listen, whatever offer Raj made to you before is no longer valid. You should have taken it while it was available. Instead, we want 12 months. What I can tell you is you may still be entitled to 12 months, but the employer is going to think, well, if I go back and try to negotiate, is it just going to continue going up and in the wrong direction? There's kind of a procedure to negotiating that a lot of people don't necessarily understand. It's very important that you do things the right way, precisely so that everyone feels like, the positions are compromising instead of being, cavalier about getting your matter resolved, right? So I just see it. If you come to me and say, well, listen, Luc, you told me I could get 12 months, but I tried to settle for 6. Do you think you can get me 12? I can say, yeah, maybe, but it'll be a lot further down the road than if you had started by coming to see me, right? It might be at the eve of trial or at trial. So it's definitely going to complicate things. So if you're going to negotiate on your own, stay high. Okay, stay high. Look at our severance pay calculator, look at the high end of that range and stay in that range. Because otherwise you're really going to complicate my job when I come in and try to negotiate from there. All right, so keep that in mind. Sandy has a follow-up question here. 239 subsection 8, pension, health, and disability benefits and the seniority of an employee who is absent from work due to a medical leave accumulate during the period of a medical leave of absence. Now, Sandy, I don't understand exactly the issue. Is your employer saying that they're not going to make your pension contributions while you're on medical leave? Let me know what the problem is with that, because that is what the code says, right? So you should theoretically okay, I see your question. Employee contributions out of pocket would be based on what number, since there are no wages? All right. So your employer, theoretically, the employer contributions to your benefits and to your pension would be based on what they were before you went on medical leave, right? So if you have to make employee contributions, that might be covered by your short-term disability or long-term disability plan, or the employer might simply waive your contributions during your leave. So I'd have to get a little bit more detail about what your employer is saying they're asking of you. Also, sometimes it's possible to suspend your pension and buy it back when you return from medical leave, but that can be expensive as well. So we'd have to kind of look at what exactly the issue is that your employer is stating, but my understanding is probably they want to continue to make the same contributions to your pension as they were making prior to your medical leave, which would require you to make those same contributions to your pension as well. So that's something to keep in mind. We have a question coming in from DM on Reddit. My employer let me go recently, telling me that my job was eliminated from the company and paid me out to the end of the month. I see now that they are hiring for my position. Can they do that? Is this legal? So it depends, DM, on where you're working. If you're working in Alberta, Ontario, and BC for a provincially regulated employer, then yes, that's legal. You can be terminated for any reason or even no reason, so long as you're paid adequate severance. Now, there are other jurisdictions where that's not true. Okay, so for instance, a federally regulated employee, someone who works in a federally regulated industry such as banking, telecom, interprovincial or international transportation. These are the main areas where you're federally regulated. The employer can only let you go if they've discontinued your function or if there's just cause. So if they've restructured or done layoffs, and it's a true layoff, it's a true restructuring, and they're not, the next day hiring to fill your role, then a federally regulated employer can let you go. They still owe you severance, but they can let you go. But if they're doing what is happening in your case, DEM, which is terminating you, providing you some severance, and then saying, and then hiring someone to replace you, then that's not a true discontinuance of a function. Okay. And so you have the opportunity to have the employee to be reinstated into your position with back pay. Okay. Now, I know that's also sometimes the case. I think it's in Quebec and maybe New Brunswick. I'm not called in those provinces, so I won't comment further on that. But in Alberta, Ontario, and BC, where our firm operates, if you're provincially regulated, which is 90%, if not more, of a province's employees, then an employer can let you go so long as they pay you with enough severance for almost any reason or even no reason, right? They might say, well, listen, we just want to go in a different direction. You hear that a lot. Well, that's allowed. So long as they pay you the severance, they can go in that different direction. And then we have another question coming in here from Henry. Henry asks, could you please refer me to a wrongful dismissal lawyer in Edmonton? Henry, I don't have anyone. Well, actually, in Edmonton, Alberta, we also represent employees in Edmonton. We're based in Calgary, but we represent employees throughout Alberta. So if you're looking for someone to represent you and you are located in Alberta, BC, or Ontario, then we can help. I recommend that you reach out to us at employmentlawyer.ca, and we'll be happy to discuss your options with you for going forward and pursuing your employment entitlements. So employmentlawyer.ca, Henry, that's where you want to go. I have a question coming in here from Sam Lupin. Sam is asking, I've been working under a verbal agreement for the last 4 years. I'm worried that my job is in jeopardy. Should I ask for the contract to be in writing in case I am let go? So, Sam, if you're a regular listener to the show, you'll have heard my rant a few weeks ago where I was telling everyone it's better for you, Sam, to not have a written employment agreement in this case. All right. If you're concerned that you're going to be terminated, I can pretty much guarantee that if your employer presents you with an employment contract, it's going to have a clause in there that's there to limit how much severance you're owed. If you get terminated right now, you're owed your full severance because there's nothing in writing that says you don't. Okay. So if there's nothing in writing that says you don't get your full severance when you're terminated, then it's the law that you get your full severance. Okay. So the main thing that employment contracts tend to do nowadays is limit how much severance you're owed when you're terminated, because severance can be a lot of money. Okay. And employers want to limit how much money they pay you. And so would rather you agree to sign a contract where that's what happens. If you haven't signed a contract where that's what happens, then you're owed your full severance. And to find out what your full severance might be, Sam, I invite you to visit pocketemploymentlawyer.ca. We have a calculator there that allows you to calculate how much severance you're owed. You answer 4 easy questions, and then we'll give you an estimate of what we think your severance entitlements might be. It's no obligation. You don't have to provide an email address or anything like that. Find out what you're owed, and then if you are terminated, give us a call and we'll help you make sure you get what you're owed. We have a question come in here from King Sar. King is asking, if you have been given a salary continuance and decided to use a lawyer, if there is a case, can the employer stop your continuance? Well, it depends. It depends if you've already signed the settlement agreements, King. So if you've already signed the settlement agreement, then it might be that you won't be able to get more even with a lawyer. Okay. But if you haven't signed the settlement agreement, then it's possible that the employer stops paying until the whole matter is resolved. Now, usually, if we're settling prior to a claim, we're talking about about 2 to 3 months to get your whole issue resolved. So that's something to consider. But it may be possible to keep you on salary continuance while we negotiate an extension of your salary continuance, or that we negotiate a lump sum payment of what you would be owed if you were, based on what your severance entitlements would be. So it's definitely something we'd have to see a little bit what the arrangement is. How come they're paying you your severance through salary continuance? How long the severance is supposed to go? Remember that in each province, there's a certain minimum entitlement that you're owed upon termination, that you get whether or not you sign your severance entitlements. No one who gets terminated on a without cause, whether or not they're working with a lawyer, everyone is entitled to something right away. All right. It's the minimum entitlements you have under employment standards legislation. You don't have to sign any documents to get that. So that's coming in whether you sign or not, which gives you some time to hire a lawyer and go through the process of obtaining your full severance. So I'd have to kind of see what the arrangement was, what the termination letter looked like, Henry, and what you were asked to sign. Not Henry, sorry, King. And then I can give you some better advice. So you might want to reach out to us, set up a time to speak with us. We're at employmentlawyer.ca. Employmentlawyer.ca is where you go so that you can set up a time to speak to one of our lawyers here and have your matter reviewed in more detail to get customized advice. We have a question here from Henry. Henry is asking, I was assaulted at work and recently given WCB. I won an appeal for unemployment on April 28th, 2023. I received no benefits, no COVID, no severance, and it was decided by unemployment that the employer had. Sorry, Henry, your question got cut off, but I'm seeing here the unemployment decided that you had an unsafe work environment. Okay. So I'm not sure I understand fully your question, but Henry, if you were unable to return to work because you were assaulted at work, it may be that you're entitled to severance, all right? So definitely we'd have to get a bit more details of what happened and whether you're still on WCB or not. But definitely reach out to us. I have a ton of clients in Edmonton, and I go up there when I need to represent them in court matters, or there's a lot of remote appearances as well. So definitely we have a lot of our practice here in Alberta is based in Edmonton, Red Deer, Fort Mac. We're all over the place. Absolutely. I have another question coming in here from Frank P. If I'm the highest ranking exec in Canada and my boss is in the US has a reputation for bullying, how do I request stress leave that's medically advised? What is the proper protocol to avoid negative repercussions, especially if there's no immediate replacement? Is giving advance notice a must? So Frank, no. If you're going on medical leave because of stress, what you need to do is, firstly, you have to start by going to see your doctor. Okay, so go see your doctor, discuss the matter with your doctor, and discuss what your doctor wants you to do. If your doctor wants you to go on a stress leave, your doctor will give you a medical note that you would then send to your company, either the Human Rights Department or what have you. If your immediate boss is your employer in the States, then that's who you send it to. Better to go through HR if possible, but otherwise, you have to send it to your immediate supervisor. So that's for going on stress leave. If the stress leave is caused by a toxic workplace, because you're employed in Canada, Canadian employment law applies to you. And so what you have the opportunity of doing is making a complaint to your HR department, if there is one, based on workplace harassment and potentially workplace violence. So all three provinces, Ontario, Alberta, and BC, require that employers have a workplace violence and harassment policy that allows for employees to make harassment complaints that can then be investigated by the company. Okay. And if there is a finding that you've been harassed in the workplace, then the company will take appropriate steps to deal with the issue, including potentially disciplining the harasser, which would then potentially allow you to return to a workplace that is free from harassment and bullying. Okay. So that's, I think, based on what you're telling me, the only way you can really return to this job is if it's free from harassment and bullying. And if the employer doesn't comply with their obligations, then that gives you a strong leg to stand on to say that you've been constructively dismissed and that you're owed severance. But probably right now you're not in the greatest of headspaces. I understand that. So my advice to you, the simplest takeaway from what you should do today is go see your doctor. All right. The first thing to do is always take care of your health first. Once your doctor has agreed that you should go on stress leave, then you can think about bringing the complaint. It may be easier for that complaint to be investigated while you're off home, rather than having to deal with potential repercussions at work or anything like that. Now you're concerned about negative repercussions. I can tell you that stress leaves are covered under the disability section of human rights legislation, and harassment complaints are covered under health and safety legislation, and both require the employer to not retaliate against an employee who has sought an accommodation, in this case a medical leave, or sought to be free from a harassment-free workplace, in this case by making a harassment complaint. So that if you do suffer negative repercussions, you have additional grounds to claim compensation. So this system is built to allow you to enforce your rights, and you shouldn't receive negative repercussions for enforcing your basic right to work in a harassment-free and bullying-free workplace. All right. So if you do suffer any negative repercussions, you can talk to me. We can talk some more about what your options are. Rash Sharma is asking, can you explain more about inducement? How can it be proved? My employer terminated me without cause in 11 months with 1 week's severance. I was induced from my previous company when I worked for 5+ years. So how can inducement be proved? A few things you're looking for when you're induced, okay? So first thing is you generally didn't apply for the job on your own. Instead, the company reached out to you and talked to you about the position, all right? We see it a lot, with recruiters or even people reaching out directly from the company that induced you. So they say, why don't you come work for us? Here's, what we have to offer. It's materially better than what you're currently working at. Why don't you come work for us? All right. Then you want to think about, well, what is it that's materially better? You might have been in a company, where there was no growth possibility going forward, and they tell you, you'll have room to grow in this new company. We're looking to develop a new market. We want you to head it, things like that. You're going to be at the head of this new department that we're creating. You're going to go into a managerial role. What did they promise you that made this offer enticing? Okay. And then you got to look at, did you sign an employment contract when you signed? So a lot of people, this is where it gets kind of tough. They sign an employment contract. It seems to them like a very standard employment contract, but what's in there is a probation clause. So the inducement kind of argument that you're making is like, I would have never left my old secure job for your job just to be terminated 11 months later, right? Instead, you deceived me into thinking I was coming to your job to have, secure employment. And now that deception has been revealed, and I shouldn't be treated as an 11-month employee. The amount of time that I worked at the other company should factor in to how much severance I'm owed. All right. The problem is when you sign a probation clause, when you agree to a probation clause in your employment contract that says you can be terminated for any reason in the first 3 months, of your employment, well, you'll be asked, well, how could you reasonably expect that you had secure employment if you were agreeing that they could terminate you within 3 months with no notice, right? So there's a conflict with what you're saying you thought was going to happen and what you contractually agreed to with the probation clause, right? And it's a huge gotcha, and I'm not a huge fan of it, I got to say, but I see it a lot. And it's courts have decided almost automatically, if there's a probation clause, it kind of nullifies the inducement argument. So first thing you want to do there, Raj, is go back and look at your employment contract. If there is no probation clause in there, then it might be, and you were kind of recruited, it could be that you have a claim for inducement. If, however, you're looking to leave your job, you saw a post on LinkedIn or on Indeed saying that there was this other job and you went ahead and applied for it unprompted, then there wouldn't be an inducement argument. There has to be something on the company's behalf to kind of recruit you. All right, so we have time for one last question here. We have time for the last question from Just, and then I'm going to answer your question, Frank, because I don't want to leave you in the lurch. I'm going to stay on a little bit longer just to answer your question. I just saw your answer come in. Just is asking, is there a difference regarding vacation if the employment contract is common law? Nothing regarding vacation or ESA. So if there's nothing in your contract that deals with vacation, then unless there's something else, a policy or something else stating your vacation entitlements, then you're owed only the minimum entitlements to vacation pay under the Employment Standards Act in the province where you work. So for instance, in Alberta right now, the minimum you're entitled to in vacation is 2 weeks for the first 5 years. And after that, it goes to 3 weeks. All right. So if there's nothing that says otherwise, then you're entitled to those minimums only. Employers and employees can agree to a higher amount of vacation, obviously, but there has to be that agreement, right? If there is no agreement as to vacation, then you're owed only the minimum. Okay. So Frank followed up, my doctor advises me to leave as soon as possible. Do I need to provide notice or find a replacement? Can they pursue legal action if I leave? So no, Frank, you don't need to provide notice. If you've been cleared to go on medical leave by your doctor, I would say you have to send a note, but you don't have to provide notice. No, you don't. Okay. This is your health, and so nothing, basically what your doctor is telling you and telling your employer in that note is that you're unfit to work in any capacity, right? So how can you give notice and continue to work against your doctor's recommendation if your doctor is saying you're not fit to work? So if that's what your doctor is saying in your doctor's note, saying, Frank can't come to work for medical reasons for the next 3 weeks or whatever, that means, you stop working the minute you send that email along with the medical note. All right. So my name is Lluc Cerda once again. I'm the managing associate of our Calgary office. I'm a bit under the weather, so thank you all for your patience with me today. I hope I answered your questions. If you have further questions, you can reach out to us at employmentlawyer.ca. Our firm has a LinkedIn site profile. I have a LinkedIn profile. Remember to like and share the show if you enjoyed it today. And thank you all for attending. It's great seeing you guys again. We're back again live tomorrow at 10 p.m. Eastern Time, 10 p.m. Pacific Time, I believe, for our disability law Q&A with Martin Willems in our Vancouver office. Thank you all for joining, and we'll see you soon. Bye now.